they just can't have any contact with her. But it seemed like several of them were concerned about the fact that an excused juror is here, and again, it's juror 901. These are public proceedings. She has every right to be here if she wishes to be here. I don't have a problem at all with her being here. But I just want to make sure that the jurors understand that there's nothing wrong with that, just as long as they follow the advisement. Is there any objection from the people?
No, sir.
Mr. King, from the defense?
No, Your Honor, and I have no objection to you telling them that it's a public proceeding and there's nothing wrong with her being here as well.
Okay, thank you. All right, let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Welcome back, members of the jury. A couple of things before we proceed. Number one is, a few of you may have noticed, perhaps more than a few of you, that one of the jurors who has been excused from the trial is present in the courtroom. Juror 901 is here watching the proceedings. These are public proceedings, and so there's nothing wrong with her being here in attendance. She knows about my advisement to you that you cannot have any contact with her or any of the other excused jurors. And I have no doubt that she will abide by my advisement. And so I just wanted to make that clear for everyone. The second thing is, I think I mentioned yesterday that it is likely we're going to take a few days off next week. And most of you seemed happy about that, but I also understand that that feeling may not be a feeling that all of you share. There may be different reasons for that. I just wanted you to know we're not taking time off just to take time off. There's actually, there are some things that we can't avoid and require us to take some time. And there are things we need to work on, for example, jury instructions. The instructions that I'm going to be giving you at the end in writing that I've mentioned to you before. And so the lawyers and I are going to be taking advantage of that time when you're not here to do some work anyway. And so at some point we were going to have to take some time to do that, and it just made sense to do it now if we could. And so we're going to be working on that to some extent. Does everybody understand that? Okay. So I just wanted you to know it's unavoidable. It's not that we're just all taking 3 days off and going on a trip or something and taking a vacation. All right. With that, at the end of the first part of the afternoon session, you had submitted some questions for Dr. Feinstein. And before we proceed, I want to remind Dr. Feinstein that you are still under oath. And I want to remind you, members of the jury, that the court has admitted the testimony of Dr. Feinstein only for a limited purpose. You may consider this testimony only as to the issues raised by the defendant's plea of not guilty by reason of insanity. You shall not consider this evidence for any other purpose. Does everyone understand that? And everyone saying yes or nodding their head yes. Great. All right, doctor, the jury has submitted some questions, and based on the rules of evidence and other applicable rules of law, I have determined that they are appropriate, and so I am going to ask you the questions now. The first question is, have you had in your years of practice a misdiagnosis with a patient that then the patient became violent?
No.
The next question is, if you were aware that he had a disregard and/or dislike of Dr. Fenton, why didn't you see Mr. Holmes without her presence?
We were exploring that transfer, and you do that together, you come to a group decision, and so at the point at which Dr. Fenton and Mr. Holmes agreed that his care should transfer to me, that's when I would start to see him alone.
The next question is, what are the side effects of Risperdal?
Risperdal can cause weight gain. It can cause mild sedation. It can cause a spectrum of side effects such as a tremor. It can cause a restlessness such that you have to move and walk. It has the potential to produce a symptom where your body gets rigid and your muscles get tight and you develop high fevers. It can cause some light movements of fingers and toes against your will. It can cause weight gain. It can also potentially cause gynecomastia, where your breasts develop and produce milk. All of those side effects are relatively infrequently, but those are possible side effects.
All right, the next question is, if someone comes to you with homicidal thoughts / ideations, is it common for the patient to ask for help in getting rid of those homicidal thoughts?
Often that's very common, especially in that group of patients where those thoughts are disturbing to them. There are a group of patients where the thoughts are not disturbing to them and they may or may not want help.
The next question is as follows. Does a person have to meet certain criteria for an involuntary medical hold, or can a psychiatrist put a patient on a medical hold because of a gut feeling?
There's very specific mental health hold rules in Colorado and all the other states that require a specific target, a specific time frame to be able to put somebody on mental health hold. And the criterion is danger to self, danger to other, or gravely disabled. So you need those criterion to be able to put somebody on a mental health hold, and we never felt that Mr. Holmes met those criteria.
You may have answered part of this question, but I'll ask it and then you let me know if you have or have not answered all of it. The question is, what is the full list of criteria that must be met to place someone on a 72-hour mental health hold, and is it subjective?
It's, just to clarify, it's danger to self, danger to others, or gravely disabled. And those are always best clinical judgment that is aided, if you use them, by some rating scales like the VASA scale that I described to inform and standardize your judgment. But it's always about clinical judgment. It's never about a black and white or a yes and no or a definitive answer.
The next question is, if you had concerns with James Holmes's homicidal thoughts, yet he didn't meet the criteria for involuntary 72-hour hold, did you ask him if he would go into a hospital willingly?
I don't believe we asked him. I didn't ask him that question. I'm not sure whether Dr. Fenton did or not.
And the last question is, you indicated in your testimony that paucity of speech, stilted speech, and inability to communicate are symptoms of a mental disorder. What disorder or disorders are you referring to?
It may be a symptom of a mental disorder. It's not always. The spectrum would be personality disorders, in which schizoid personality, schizotypal personality, maybe even paranoid personality disorders might be personality disorders where you see a paucity of thought. Other schizophrenic spectrum diagnosis, schizophrenia proper, schizoaffective disorder. Some of the autistic spectrum disorders, Asperger's autistic spectrum disorders, might also reveal a paucity of thought, as well as developmental delays. Folks with low IQ or have had brain damage of one sort or another may show a paucity of thought as well. So it's a pretty wide differential diagnosis.
All right, are there any follow-up questions, Mr. Brockler?
Yes, Your Honor. Doctor, in your experience, and one of the questions had to do with whether or not a voluntary hospitalization was offered. In your experience, someone who turns down free follow-on health care, is that someone who, in your experience, is likely to take you up on something more restrictive like a voluntary hospitalization?
Objection, Your Honor. Calls for speculation.
Sustained. You can ask a different question. I know what you're getting at, but sustain us to the form of the question.
What factors might you have considered in not offering a voluntary hospitalization as an extra step beyond what happened?
I think if outpatient is the least restrictive form of therapy, it's totally voluntary, totally up to the patient, and if they don't accept that, it wouldn't make sense to offer a more restrictive kind of therapy for a patient.
I want to ask you, too, as you went through the criterion that you described for an involuntary hold, you talked about dangerousness to self or others. Is that a someday could be dangerousness or an imminent gonna happen dangerousness?
It's an imminent gonna happen within a matter of minutes or days.
Nothing further, Your Honor. Thank you.
Any follow-up questions from you, Ms. Higgs?
Yes, Your Honor. I'm sorry, I'm trying to figure out my notes. Doctor, you talked about this idea that some people come in with homicidal thoughts and they ask for help with them, correct?
Yes?
Okay. Now, when Mr. Holmes came in to see Margaret Roth on the very first date of his intake appointment, he talked to her about the symptoms he was having, correct?
Yes?
And one of the things she asked him about was other symptoms after he talked about the anxiety and the public speaking, correct?
Yes?
And he said he didn't want to say, as she would have to report him, but he says he wants to kill other people, correct?
That's what the note said, yes.
So when he initially came for his treatment, one of the symptoms he did report was his homicidal ideation, correct?
Yes.
Okay. Now, with regard to a voluntary hold or actually an involuntary hold, it's possible that when somebody goes into the hospital that they may actually decide at that point, I'm going to actually take this antipsychotic medication. I'm going to take this thing that's going to help me. That's possible, isn't it?
Your Honor, it calls for speculation.
Sustained.
With regard to the emergency statute, you said that it has to be imminent within minutes or days. Is that right?
Yes.
What the statute actually reads, Dr. Feinstein, is that when a person appears to have a mental illness and as a result of such mental illness appears to be in imminent danger to others or to himself or herself, or appears to be gravely disabled, then a person such as yourself can then effect a 72-hour hold, correct?
Yeah.
The statute doesn't say imminent within minutes, correct?
Right.
The statute doesn't even say imminent within days, correct?
Correct.
Okay. I have no further questions. Thank you, Your Honor.
All right, may Dr. Feinstein be released from his subpoena?
Yes, sir.
Is there any objection?
No, sir.
Dr. Feinstein, thank you. Call your next witness, please.
Detective Craig Apple.
solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, please be seated.
Judge, before we begin, we're calling Detective Apple for just a limited purpose. He may be recalled later in the trial.
Okay, and Detective, you've testified before, but could you please state your name for the record again, since it's been a while?
Craig John Apple, Craigjohnappel.
All right, Mr. Edson, you may proceed.
Thank you, Your Honor. Detective Apple, are you the lead detective for the Aurora Police Department in this case?
Yes, I am.
Were you a detective with the Aurora Police Department back on July 20th, 2012?
Yes.
As part of your duties and background in becoming a detective, have you had an opportunity to have some experience with firearms?
Yes.
As the lead detective in this case, have you had the duties and responsibility to review all of the evidence and documents and information associated with this case?
Yes.
If I could please have People's Exhibit 4506. It's already been admitted, Your Honor.
Okay?
We could scroll into the top there. Detective, do you recognize this?
Yes.
What is this?
Looks like it is a Gander Mountain sales receipt from May 22nd of 2012,
And what was the time of this particular purchase?
4:34 p.m.
And have you been present during all testimony to date at trial?
Most of it, yes.
Okay. Were you here during testimony from another witness from Gander Mountain related to this particular exhibit?
Yes.
Do you recall who was associated with this exhibit as far as the purchaser?
Yes.
Who was that?
The defendant, James Holmes.
Okay, thank you. You can take that down. Did you personally interview the defendant previously? You personally had an interaction with him, is that correct?
Yes, twice.
Your Honor, may I approach the witness, please?
Yes.
This would be People's Exhibit 532A. I've handed you what's been previously marked as People's Exhibit 532A. Do you recognize that exhibit?
Yes, I do.
What is that exhibit?
It's a DVD, real short clip of a Gander Mountain surveillance video from May 22nd, 2012.
Did you yourself view that surveillance video?
Yes, I did.
Is there any markings on that particular exhibit that are from you?
Yes, I placed my initials and the date I viewed it, which was this morning.
Did you observe anyone you recognize on that surveillance video?
Yes, I did.
Who did you recognize?
The defendant.
That would be James Holmes?
Yes.
Were you able to view the time that's at least reflected on that particular video?
Yes.
Did that time closely reflect in time to the time on the Gander Mountain receipt you just testified to?
Yes, it did.
Your Honor, may I approach the witness, please?
Yes.
This is People's Exhibit 361A. Sir, do you recognize this exhibit?
Yes, I do.
What is that exhibit?
Your Honor, I neglected to do this before, but I'm not going to neglect this time. I don't think that it's appropriate for this witness to talk about what's on this video until this video has actually been introduced with any specificity.
Judge, if I may,
Yes.
I'm laying foundation for its admission.
All right, lay foundation to the extent you can without going into the contents of the video.
Understood. Without getting into the contents, what in general is People's Exhibit 361A?
Surveillance video from Gander
Objection,
Mountain.
Your Honor. I don't think that he can talk about where it's specifically from.
Sustained.
People's Exhibit 361A is that surveillance video.
Yes, it is.
Did you yourself view that surveillance video?
Yes, I did.
Did you recognize anyone from that surveillance video?
Yes, I did.
Who did you recognize?
James Holmes.
If I could please have People's Exhibit 2772. It's a photograph already admitted into evidence. Sir, what are we looking at here?
We are looking at the Remington 870 12-gauge shotgun that was used in this shooting on a theater floor.
What is the caliber of ammunition for that particular weapon?
12-gauge.
We could have People's Exhibit 2190 also already admitted. What weapon are we looking at here?
This is a M&P, or Smith & Wesson M&P rifle, 223 caliber, found outside the theater in the rear door.
We could have People's Exhibit 2156, please. What are we looking at here?
This would be the Glock pistol used in this shooting. It's 40 caliber with a sighting accessory on the bottom of the slide.
We could have People's Exhibit 2149 also previously admitted. What are we looking at here?
This is a 40 caliber Glock pistol found in the front passenger door side.
We can take that down, thank you. Your Honor, may I approach the court reporter to retrieve some evidence?
Yes.
Sir, I've handed you what's been previously admitted as People's Exhibit 706. What is this exhibit?
This would be the M&P, Smith & Wesson M&P rifle used in this incident.
Have you previously viewed this rifle prior to your testimony today?
Yes, I actually packaged it and secured it in this box.
Can you observe whether there is a sight or a mount on this particular exhibit and the weapon inside this exhibit?
Yes, attached to the rifle on the top rail system is a Vortex strike fire aiming system, and attached to that is a clamp that allows it to attach to the top of the rifle. This AR platform is called the rail system.
Is that also known as a mount?
Yes.
Judge, one moment, please.
Yes.
I have nothing further, Judge. Thank you.
All right, any cross-examination?
No, Your Honor.
All right, thank you, sir. Call your next witness, please.
Jose Lopez.
Good afternoon. Could I have you raise your right hand for me so that I can administer an oath? Do you solemnly swear or affirm on the penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I do. Please be seated. Could you please tell us your full name and spell your first, middle, and last names?
My name is Jose Lopez. My name is spelled Jose. Middle name is Felis. Last name is Lopez.
Mr. Edson, you may proceed.
Thank you, Your Honor. Sir, do you also go by the first name of Joe?
I do.
How are you currently employed?
I'm a bench store manager for Gander Mountain.
What is a bench store manager?
I'm basically a store manager in training. I've completed the training, so I'm a bench store manager.
Were you employed with Gander Mountain back on July 1st, 2012?
I was.
Were you employed by Gander Mountain back on July 20th, 2012?
Yes, I was.
Have you been employed continuously with Gander Mountain since that time period?
Yes, I have.
Mr. Edson, I'm sorry to interrupt you. There's something we have to take up, so let's take a short break, folks. Members of the jury, please keep in mind that my advisements apply during the break. So let's take a 10 or 15 minute break, okay? Thank you. And we'll have the witness step out as well, please. Please be seated, everyone. The record should reflect that we are now outside the presence of the jury and outside the presence of Mr. Lopez, the witness. I received a note from juror number 527 indicating that he knows this witness. So I've marked the form, by the way, as question form number 194. Let's bring him in. This is number 527. The record should reflect that juror number 527 is now present in the courtroom. Have a seat. Good afternoon.
Afternoon.
How are you doing?
Good.
It's a loud mic.
It is.
The reason I brought you in is because I want to follow up on the form that you submitted indicating that you apparently know this witness, Jose Lopez. Is that right?
That's correct.
Okay. How do you know Mr. Lopez?
Friend of my brother-in-law. We played fantasy football together.
Okay. How well do you know him?
We communicate throughout the football season, so we've hung out a couple times.
How would you describe your relationship with him? Do you think he's an acquaintance or more of a friend or something else?
Between acquaintance and friend.
Okay. And approximately how long have you known him?
Been in this league for 8 years.
When was the last time you had any communication with him?
Last fall.
And
We're also Facebook friends too. So
when was the last time you communicated with him through Facebook?
I don't know. I don't remember.
Was it before the trial or after the trial
It was
started?
probably before the trial.
Are you planning on having any further communications with him before the football season?
No.
No? Okay. And so that would be sometime when?
Usually it's after Labor Day.
Okay.
I think right around Labor Day.
All right. Anything about your relationship with this witness that you think would affect your ability to be a fair and impartial juror in this trial?
No.
Anything about that relationship that you think would affect your ability to assess the credibility of this witness in the same way that you assess the credibility of all other witnesses?
No.
Anything about your relationship that in any way would affect your ability to follow my instructions, including the instruction on how you go about assessing credibility, the credibility of the witnesses?
No.
Do you think that anything about that relationship will influence you or affect you in any way in deliberations or in making any of the decisions in this trial?
No.
Do you have any concerns at all?
No.
Let me have you step out for just a moment, okay? Okay, the record should reflect that juror number 527 has stepped out of the courtroom. Any additional questions that the people would like me to ask?
No, sir, but I appreciate his candor in coming forward immediately.
Okay. Any requests that the people are making to the court right now, Mr. Bruckler?
No, sir.
All right. Mr. King, do you have any additional questions that you would like me to ask?
No, not at this time.
And any requests of the court at this time?
No, sir.
Okay. All right, thank you. Let's bring the jury back, please. Actually, Ms. Robinson, can we have juror number 527 back, please? Can everybody be seated? The record should reflect that we remain outside the presence of the jury and outside the presence of the witness. The record should reflect that juror number 527 is back in the courtroom. Sir, thank you for your patience. I'm going to ask that you not have any contact with Mr. Lopez until after the proceedings are completed. Are you okay with that?
Absolutely.
Okay. Will you promise me that you will have no contact with him at all?
Absolutely.
And I'm going to ask you to also promise me that you will not discuss with any jurors anything about your relationship with Mr. Lopez or your knowledge of him or anything like that. Will you promise that you will do that?
They already know.
They already know? Okay. How did they know?
I don't know. Because they saw me give the paper.
They infer from your
Yeah.
giving the note that you know this witness. But you haven't discussed it?
No.
And will you promise that you will not discuss it?
Yes.
Okay. All right. In terms of the Facebook page or your Facebook account, is there any way to avoid any contact with him?
Oh, yeah, absolutely.
Okay. I'm going to ask that you do that. Will you do that?
Absolutely.
At least until the proceedings are completed and we're done, okay?
Okay.
All right. And please don't discuss any of this with the other jurors.
Okay.
All right. Thank you. The record should reflect that juror number 527 has now exited the courtroom again. I'm also going to order that the people instruct Mr. Lopez not to have any contact with this juror until after the proceedings are completed, okay?
Understood. Thank you, Judge.
And that includes Facebook. Yes. All right, thank you. Okay, now let's bring the jury in, please. Please be seated, everyone. Welcome back, members of the jury. Thank you for your patience. Mr. Lopez, I remind you that you're still under oath. Mr. Edson, you may resume your direct examination of Mr. Lopez.
Thank you. How long have you been employed with Gander Mountain?
5 years.
Is there a particular store that you worked at back in July of 2012?
Yes, I worked at the location on 14,000 East Jewel Avenue in Aurora, Colorado 80012.
Is there a particular store number associated with that store?
Yes, it's 420.
What was your job title back on July 1st, 2012?
I was the Hardlines Zone Manager.
What was your job title back in May of 2012?
It was the same, Hardlines Zone Manager.
Are you familiar with transaction journals?
Yes, I am.
How are you familiar with Gander Mountain's transaction journals?
I'm basically a custodian of records. The transactions that are placed, different sales transactions are processed, and they create a record, which becomes that journal.
Do you have access and authority to view transaction journals as part of your job?
I do.
Your Honor, may I approach the witness, please?
You may.
I've handed you what's been previously marked as People's Exhibit 1100. Do you recognize that?
I do.
What is that?
It's a copy of a transaction journal from July 1st, 2012.
Have you previously had an opportunity to view that transaction journal?
Yes, I have.
How was that particular transaction journal created?
Through the course of a purchase of, in this case, 4 items.
Is that transaction journal electronically stored at Gander Mountain?
Yes, sir, it is.
Is that transaction journal a computer record?
Yes, it is.
Are those records of that transaction journal computer generated?
This one is yes.
Are the computer entries made in the regular course of Gander Mountain's business?
Yes.
Those participating in the making of that record, are they acting in the routine course of business for Gander Mountain?
Yes, they are.
Are the input procedures accurate for that particular record?
Yes.
The entries that make up that record, were the entries made within a reasonable time after the transaction involved?
Yes.
Is the information transmitted by a reliable person with knowledge, such as yourself, of that particular transaction journal?
Yes.
Does Gander Mountain, based on your knowledge as a bench manager, regularly receive, maintain, and rely on information transmitted in the course of business for those records?
Yes, we do.
Is any information provided by the customer, including payment methods, used as part of a business relationship between yourself as Gander Mountain and that particular customer?
Yes.
And does Gander Mountain substantially rely upon information provided by the customer in creating those records?
Yes, we do.
Does it appear that that transaction journal has been altered and tampered with in any sort of way?
No, it does not.
And I would move for admission of People's Exhibit 1100.
Is there any objection to P-TR-1100?
No, Your Honor.
All right, without objection, P-TR-1100 is admitted and may be published.
We could have the first page of People's Exhibit 1100, please. Sir, you'll be able to see it on your computer screen right in front of you. Can you tell the jury what is the date of this transaction?
July 1st, 2012,
What was the time of this transaction?
3:51 p.m.
The store there, 420, was that your Aurora store?
That's correct.
We could scroll down a bit, please. Can you describe what the items that were purchased on this particular transaction?
It looks like 3 separate snap caps, one for a 12-gauge shotgun, one for a .223 rifle, and one for a .40 caliber handgun.
If we could scroll down a bit more, please. Is there an additional item there?
Yes, it looks like a Strike-Fire mount, Strike-Fire with an AR mount, red dot optic.
If we could go to the second page of this exhibit, please. What was the total amount of this transaction?
$233.23.
How was this transaction completed as far as payment method?
It was a debit card,
What were the last 4 digits of that debit card?
8522.
Your Honor, may I approach the witness, please?
You may.
I've handed you what's been already admitted into evidence as People's Exhibit 720. There's 3 cards on there, but People's Exhibit 720 is what I want you to focus on. What are the last 4 digits of that particular exhibit?
8522.
Okay, you can go ahead and set that down, please. We can take that down, thank you. In the days after July 20th, 2012, were you requested by law enforcement to turn over any DVR system for your Gander Mountain store?
Yes, sir, I was.
And did you comply with that request?
Yes, we did.
Are you familiar with the video surveillance system at Gander Mountain?
I am.
As your current title, do you have access and authority to view and maintain the video surveillance at Gander Mountain?
Yes, I do.
Did you also have that knowledge of video surveillance system back in July of 2012 when you assisted law enforcement by providing the DVR?
Yes, I did.
Your Honor, may I approach the witness, please?
You may.
So I've handed you what's been previously marked as People's Exhibit 532A. Do you recognize that?
I do.
What is that, just in general?
It's a copy of surveillance from our store.
Did you personally view that surveillance video?
I have viewed it, yes.
How do we know that that's the particular copy that you viewed?
I initialed it and dated it.
Is that video surveillance from the Aurora 420 store?
I believe it is.
What is the date of that particular video surveillance?
May 22nd, 2012.
If I could please have People's Exhibit 4506 on the screen again, please. Do you recognize the top of this exhibit?
I do.
What is that?
It looks like the header of one of our receipts.
You see where the time is?
I do.
What is the time of this receipt?
4:34 p.m.
Does that approximately correspond with the time of the People's Exhibit 532A that you viewed?
It does.
Thank you. Based on your view of People's Exhibit 532A, does it appear to be altered or tampered with video in any sort of way?
No, sir, it does not.
I would move for admission of People's Exhibit 532A.
Is there any objection?
There is, if I could approach, please.
Yes. Thank you. All right, the objection is overruled. The exhibit was it P-TR-532A?
Yes, sir.
P-TR-532A is admitted and may be published.
Thank you. Could we actually go back and put on the screen People's Exhibit 1100, the first page of that, please? We could scroll down just to the purchases. Sir, you talked about 3 different purchases of snap caps. Are you familiar with what snap caps are?
I am.
What are they?
They're typically dummy rounds that are designed for training purposes,
Okay.
as well as function checking firearms.
Okay, thank you. We can take that down. Your Honor, may I approach the witness, please?
Yes.
This is 361A. Sir, I've handed you what's been previously marked as People's Exhibit 361A. Do you recognize that exhibit?
I do.
What is that?
It looks like surveillance video that I viewed from our store.
Okay, the Aurora Gander Mountain store?
Yes.
That appear to be from what date?
July 1st, 2012.
That particular video, did you assist law enforcement in collecting that as well when you turned over the DVR?
Yes, sir, I did.
Is that a fair and accurate representation of surveillance video from July 1st, 2012?
Yes, sir, it is.
And actually, I'll just ask one more time, People's Exhibit 1100, if we could publish the first page. Just so you have it in front of you, what was the time of this transaction from July 1st, 2012 on People's Exhibit 1100?
3:51 p.m.
And we go ahead and take that down, thank you. People's Exhibit 361A, does that surveillance video roughly encapsulate that time period?
It does.
And I would move for admission of People's Exhibit 361A, please.
Ms. Higgs.
Your Honor, I make the same objection incorporating my arguments to the bench.
All right, thank you. The same ruling, incorporating my ruling at the bench with respect to the last exhibit, P-TR-532A. So, P-TR-361A is admitted and may be published.
Your Honor, may I approach the witness, please?
You may.
For the record, Your Honor, we will now be publishing People's Exhibit 532A. This is the May 22nd, 2012 surveillance video.
And this one, it has no sound, right?
Correct.
And how long is it?
46 seconds, I believe.
All right, do you want me to dim the lights?
Please.
Okay, the record should reflect that the people just finished playing P-TR-532A.
Sir, in the last portion of that exhibit, it appeared that there was a sales associate on screen. Did you see that part?
Yes, sir, I did.
Is it common for sales associates to escort customers to the exits once they purchase a firearm?
Yes, it
Is
is.
that what was happening in that portion of the video?
Yes.
Judge, for the record, we're now publishing People's Exhibit 361A. This is the July 1st, 2012 Gander Mountain surveillance video. Has no sound. It's 1 minute and 37 seconds.
All right, would you like the lights to be dimmed?
Yes, sir. Thank you.
The record should reflect that the people just played Exhibit P-TR-361A.
Judge, can I have one moment, please?
Yes?
Your Honor, I have no further questions at this time. Thank you.
Thank you. Is there any cross-examination, Ms. Higgs?
Yes, just very briefly.
Okay.
Mr. Lopez, on either of these occasions, May 22nd or July 1st, you yourself did not have any direct contact with Mr. Holmes. Is that correct?
That's correct, ma'am.
Thank you. Nothing else, Your Honor.
All right. Is there any redirect, Mr. Edson?
No, thank you.
All right. And the jury does not appear to have any questions. May Mr. Lopez be released from his subpoena?
Yes, Your Honor.
Is there any objection, Ms. Higgs?
No, Your Honor, there is not.
Okay. Mr. Lopez, thank you.
Thank you.
Would counsel please approach to talk about scheduling? Members of the jury, it's a little bit before 5, but I'm sure you won't mind if we quit a little early today. No? Okay, let's do it then. We're going to go ahead and adjourn for the day. Please make sure that you follow all my advisements tonight and tomorrow before you get here. I gave them to you yesterday. I've given them to you about 20 times probably by now. I'll be giving them to you again. The reason I do that is because they're extremely important. So we'll talk about them again tomorrow before the long weekend and the long break. Enjoy your evening. Get some rest. I'll see you tomorrow morning. Thank you for your time today. Hey, Connie. All right, please be seated, everyone. The record should reflect that the jury has exited the courtroom now. Since we have a little time, we should probably talk about P-TR-347A, the Hotmail emails. I had a chance to review them during the lunch hour and during the afternoon break. I have some concerns, and so I need to ask Mr. Edson a question about the hearsay objection. Tell me again what your response is to the hearsay objection, Mr. Edson.
Our response is the same as the response for Gmail, referring to the emails that have any correspondence in there between Mr. Holmes and another party. For that purposes, the Mr. Holmes' statements are not hearsay, and any other comments are there for context and not for the truth of the matter asserted. Related to the transactions, I made this record at the bench, Judge. Some of the transactions has response from Mr. Holmes, others do not. That places in context the fact that Mr. Holmes and the mental state of Mr. Holmes regarding the insanity plea, that he responds to some, not others, has questions or concerns about some of them, but not others as well.
The concern is that this is a large exhibit that includes all kinds of documents, and they're not all of the same type. So this is different than P-TR-1227. P-TR-1227 contain only emails. Now, there were some attachments to the emails, and the attachments were schoolwork that apparently Mr. Holmes completed. And I don't have any concerns that the jury is going to consider the statements in the schoolwork for the truth of the matter asserted, but I'm happy to give an instruction on that if the defense wishes to have me give an instruction that any schoolwork that has been admitted that were attachments to emails in P-TR-1227 was only admitted for the limited purpose of considering the issues that are raised by the not guilty by reason of insanity plea. If the defense wants such an instruction, I'm happy to give it, and that way there's no concern. But I really don't have any realistic concern that any of the jurors are going to be thinking that those documents were admitted for purposes of the truth of the contents of the documents. In other words, for neuroscience types of concepts and discussions. Everybody understands that's not what the trial is about. But again, if an instruction is something the defense wants, I will give it. The problem with this particular exhibit, P-TR-347A, is that, yes, it contains some emails between Mr. Holmes and other people. And so to the extent that there are email exchanges, I will treat them for hearsay purposes the same way that I treated them in other exhibits, and that is to say the statements by Mr. Holmes are statements or admissions by a party opponent, and they're not hearsay. The statements by the person emailing him or that he's responding to or that who's responding to him are statements that are not admitted for the truth of the matter asserted, but they are admitted only to place in context Mr. Holmes' statements and only to make Mr. Holmes' statements intelligible. But this exhibit goes beyond that. This exhibit also has, for example, a confirmation document from La Quinta, Inns and Suites. So this is not something that Mr. Holmes is responding to, and there is no email from Mr. Holmes. I don't believe. This is just a confirmation of a reservation that apparently he made. There are some other documents that are apparently being admitted for the truth. For example, you have some documents in here from 24-Hour Fitness. Again, this is not part of an email exchange between Mr. Holmes and someone else. It's just documents from 24-Hour Fitness. There are some documents from some of the merchants that have been mentioned. And yes, it's true that some of them are email exchanges with Mr. Holmes, but others are not. Others are just confirmation emails that the merchants are sending. And furthermore, I think the people are introducing those for the truth. They're introducing those to show that he purchased those items that were found in the theater and that were allegedly used in the shooting or allegedly used in his apartment. So even if it's email exchanges with Mr. Holmes, they're not being introduced just to place Mr. Holmes' statements in context. They're being introduced for the truth. Same thing with the prescription from Dr. Fenton. That's in here too. And so I have concerns because parts of this exhibit would seem to me to be admissible because they're not hearsay, but parts of this exhibit are not admissible because I think they are hearsay. And I don't believe that the people established enough foundation for them to be admitted as business records. I went back and looked at my notes, and I don't believe that the people met the foundational requirements under People versus Glover. 2015 Westlaw 795690, Colorado Court of Appeals from 2015. So even if the people could get past the hearsay objections, so let's say the people were able to lay the foundation under the business records exception, I would have an additional concern, and that is I don't know what I tell the jury with respect to this exhibit without confusing them. Some of these records would be offered for the truth. Some of them would be offered to, parts of them would be offered to place the defendant's statements in context. Perhaps others would be offered only for the issues raised by the not guilty by reason of insanity plea. So it's an exhibit that's large, and it includes all kinds of documents and all kinds of information. And so I have a lot of concerns that in my mind prevent it from being admissible in its entirety. So I don't know how the people want to proceed, but I reviewed it, and those are my thoughts. And those are my main concerns. I know that there were objections in terms of authenticity and in terms of the confrontation clause and in terms of rules 401, 402, and 403, and specifically in terms of cumulative. And let me just say on the cumulative objection, Ms. Spengler persuaded me to some extent, but then there was an objection as to authenticity. So if there's an objection as to authenticity where you're actually contesting that it was Mr. Holmes who sent these emails or who received these emails, then I think I have to allow the people to include some things that have already been admitted in order to provide authenticity to the document. So you kind of have to choose your battles there. You can't, I don't think you can argue both. You can't argue that there's cumulative information in here and at the same time contest that the authenticity of the record, in other words, that the records are what they are purported to be. So that's a long way of saying that as tendered, the exhibit is not admissible. That's P-TR-347A. And before I forget, let me go back to P-TR-1227. You don't have to give me an answer now, but think about whether you want me to give an instruction with respect to any schoolwork that is included in that exhibit, as well as any other schoolwork that is part of any exhibit the jury has received. Again, I think it's common sense that it wasn't admitted for the truth of the contents of those documents, but if you want me to spell it out for the jury, I'm happy to do it. I'm happy to give the jury that instruction. So they're not hearsay because they're still statements made by the defendant, and they're admissions by a party opponent, but they weren't admitted for their truth because we're not telling the jury anything about neuroscience specifically or some of the concepts or discussions that are contained in those documents. So is this my copy of the exhibit, Mr. Edson? Do you want it back, or is this my own copy?
That can be your own copy, Judge.
All right, I'll hold on for it for now, and then if you want to think about it overnight, you can. I just thought you asked me to review it and to make a ruling on it, and Ms. Spengler, your objection on hearsay grounds is sustained because I'm finding that some of the contents of this document are hearsay and that they are not admissible, at least based on the record that's before me right now. So, is there anything else we need to talk about at this time on behalf of the people?
Can I have one moment, please?
Yes.
But two things. On Hotmail, I think the best thing that we're going to do tonight, we'll go through and I think we'll try and select the ones based on the court's ruling that would not be admissible and try and put together a packet that comports with the court's ruling. And we'll give Ms. Spangler a copy in the morning if that's acceptable. It should be, we are all familiar with the emails now, so hopefully there's enough time that we can review them. So I think that's the best approach at this point.
Okay.
Secondly, Judge, I did speak with Mr. Lopez outside and advised him not to speak with the juror. And to Mr. Lopez's candor, he knew immediately why I was talking with him, and he said, I know what this is about. And I asked him, did you know a juror? And he said yes. And I advised him exactly as the court responded. He said he understood, and he will not contact the juror on any social media, text, phone, in person, anything. He understands.
Great. Anything from the defense?
No.
Okay. Have a good evening, everyone. I'll see you tomorrow morning. The court will be in recess. Thank you.